Good morning and welcome to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. I am located at 1563 Main Street in Peckville, Pennsylvania, and I am here with you every Sunday from 8 to 9 a.m. on this station to bring you, the land owner, the valuable information that you need regarding natural gas development here in Pennsylvania. At the Clark Law Firm, my focus is on land owner, oil and gas rights owner representation. Have not, do not, and will not represent gas or pipeline companies. Have not, will not, do not represent oil and gas companies. I represent Pennsylvania landowners and oil and gas right holders for such things as, little lawyer talk here, including but not limited to gas lease negotiations, gas lease amendments, modifications, extensions, reviews of any and all natural gas related contracts, royalty deduction issues, unitization issues, pipelines have done, consulted with, worked on pipeline agreements with at least, and actually we'll say over 60 separate companies in Pennsylvania. Gives you an idea of what's going on out there. Do more and more with estate planning, surface use agreements, compressor site agreements, meter sites, essentially any and all issues related to natural gas development here in Pennsylvania, including, touch on quickly, buying and selling gas rights. If you're selling your oil and gas rights, please be careful. You have to get assistance. Just got a deed this week. Break apart here real quick. Just got a deed here this week from a client on what I'm representing them on today. But years back, they sold a property that they owned, and they told their attorney that they wanted to reserve or keep the oil and gas rights. Well, here we are years and years later, and it turns out that the attorney didn't do apparently what they asked the attorney to do, and they sold the property with the oil and gas rights. And they didn't realize this because the new buyer of the property, who has an obligation to do so but did not notify the gas company that they have purchased the property. So the gas company was sending the regular, and in this case, they were shut-in payments. They were sending them to the landowner who thought that they owned the oil and gas rights. They kept getting and receiving these shut-in payments, so they thought everything was in order. And it turns out they discover several years later that, in fact, they did not reserve the oil and gas rights that like they thought they did, and they don't own anything. And so the payments that they were receiving, they actually should not have been receiving, but since the buyer of the property never notified the company that they had purchased the property and the oil and gas rights, the company doesn't know, and they continue to send these shut-in payments to the people who sold the property. So because they're receiving the shut-in payments, they thought they still owned the oil and gas rights. Fast forward 8 or so years into the future, and it's a terrible situation, but unfortunately, they find out now that although they thought they owned the oil and gas rights for the property they sold, they do not. And that is an enormous loss for those individuals. So if you are going to sell real estate, or if you're going to sell your oil and gas rights, you get a letter in the mail, somebody comes to your house, you're going to sell your oil and gas rights, please take a step back. In fact, let me put it this way. Please take a very big step back. Big step back. Call someone, not the person you're working with who's representing the other side. Call an attorney. Call someone who knows what they're doing. We do these reviews and consultations for people who are considering selling the oil and gas rights. Sorry, don't want to make it. I don't want to make it just a lead-in commercial here, but I'm telling you, please do the review and consultation with me or somebody who knows what they're doing. But these contracts are very company friendly. You're not, people aren't telling you that when they're negotiating for the purchase of your oil and gas rights. You need to be careful. You must be represented. Before you sign anything, you need to make sure that you're speaking with an attorney who's going to represent your interest, and you need to understand why you're doing this, because frustration is there today. Frustration is rampant out there in the community. So in the landowner communities and areas of natural gas, you cannot make bad decisions out of momentary frustration, or momentary, maybe frustration over a few years. You can't make a bad decision. You have to look further ahead into the future. If it's relevant to you, you need to be thinking about your children and your grandchildren. So don't make any decision out of frustration. Do not make a decision to sell your oil and gas rights without talking to somebody who can advise you, can assist you, who can talk to you about why you're doing it, the pros and cons of doing it. But then the agreement of sale or the purchase agreement and the deeds, you have to be careful. I've seen too many cases where the transactions went no way in the world like the person thought they were going to go. You have to be careful. You have to get representation. And what the heck? Commercial alert. And I mean it, though. I have these reviews and consultations with people who are going to buy or sell their oil and gas rights, and every one of them, they come out with a lot better information, knowledge, and the ability to use that information to make the right decision for them. Not to say don't do this or do this, but to give you the information and education to allow you to make an informed and correct decision for you, your children, your family, and your property. And look, we're talking about oil and gas rights, selling oil and gas rights, but at the same time, that applies to leasing, it applies to pipelines, it applies to roadways, surface sites, anything. Same principle applies. So I'll go ahead and say it. You can always contact me, Attorney Doug Clark, 570-307-0702, 570-307-0702. You're listening to All Things Marcellus with me, Attorney Doug Clark. And now we're going to turn and dive into the issues of today's show. And I'll give you a quick little preview. We're going to talk about Tioga County again, guys. Sorry if you're in one of the other counties, but as always, these issues don't just apply to a single area. They apply to everybody, but some of the issues are more specific to certain regions. We broadcast in northeastern Pennsylvania, north central Pennsylvania, in the Pittsburgh area, in southwestern Pennsylvania. So even though you may be in southwestern Pennsylvania, you may be in northeastern Pennsylvania, I assure you that this information is valuable and helpful to you as well. But what I'm going to talk about at the beginning especially is going to be issues that are affecting Tioga County landowners. And it's the area, I say this, and the reason why I keep talking about it, in my opinion, in the opinion of Doug Clark, in my opinion, that is the area where people are signing the worst agreements in Pennsylvania at this time. It's also a very active area where landowners are being approached to sign new leases, extensions of leases, modifications of leases, pipeline agreements, roadway agreements, workspace agreements. You gotta be careful. It's a bad time, in my opinion, not specific advice, but it's probably a bad time to sign some of these agreements, and I'm going to explain why. I'm going to explain why in detail. Then I am also going to talk about pipeline agreements, and we're going to talk, it'll be a focus towards Tioga County, but we're going to talk about pipeline agreements as well, and why consider or why sign certain agreements. And I will explain why I think that it may be a time to pass on certain agreements. And I'll give some examples, at least one example of an agreement that I wouldn't spend minutes talking to anybody about if I were a landowner, because it just doesn't make sense. And there are too many agreements out there that make no sense for the landowner, and people are signing them. We need to get information. I say it all the time, and I mean it so much. We have to get people educated and informed. And if you're educated and you're informed and you want to sign any document, then that is what you should do. That is what you should do. Remember, I represent people to negotiate documents, to review and consult with people on documents. I get paid per hour generally in working for my clients. So if I say to a client, hey, look, this offer makes no sense on a review and consultation, and here's why I think so, and here's what I'm talking about. And if you agree, you say, wow, boy, that offer doesn't make any sense. Well, we're done. That relationship ends as far as, that particular subject. Of course, I'm here in the future, or if an offer is presented that does make sense, but that's the end. I'm not creating work just because I need to create work and I need to get paid on an hourly basis. I'm going to tell you, hey, look, this doesn't make any sense. So instead of paying me another dime, you should consider politely rejecting the offer. That's your decision. But generally speaking, after a review and consultation, most clients have a pretty darn good idea what they think is in their best interest. And that's all we want. That is all we want. That is what we want. We want you to sign fair contracts that you're happy with. And actually, look, we want them to be more than fair to your benefit. What does the company want? They want them more than fair to their benefit. Who's winning that battle right now? And for the past, 10 years, who's winning that battle? Well, newsflash, the company is. The company is. But you know who's not winning that battle? The company, whenever we're representing the people. Whenever we have educated, informed landowners, now the company's not just taking advantage of people. So that's what we do the show. That's why, and plug/information, whether you're looking for representation or quality information, go to pagasleaseattorney.com. Read the information there. Whether, again, you don't have to be looking for representation. Look for information, whether you ever call the office. Check out pagasleaseattorney.com. And look, you're invited to call. I'd love to hear from you. Check out pipelineattorney.com. Listen to prior radio shows. Become educated and informed. Understand they're not specific advice for you, but they're advice for you to consider when weighing your options. And as always, we're here to help you. I am here to help you, the Pennsylvania landowner. So never hesitate to contact the office, regardless of your location. I represent clients all across Pennsylvania. Landowners who have land or gas rights in Pennsylvania are located across the country and even in other countries. Do not be afraid of distance. If it's ever going to be a problem, I assure you we'll identify it early and say, hey, this is going to be a problem. But I'm telling you, it is so rare that distance is ever a problem. So don't be afraid. You can call us anytime, 570-307-0702. And I'm going to get into these issues here at the break. It's a good time to take a break. You're listening to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. I'm here with you every Sunday from 8 to 9 a.m., and I'll be right back after this extremely important message. Welcome back to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. You can join me right here on this station every Sunday, 8 to 9 a.m. Okay, let's get into this here. So I have been ranting, and I believe rightfully so, about the offers for gas leases in Tioga County. And in particular, but listen, we don't want to get too particular because there's a lot of bad offers out there. But in particular, we're talking about Shell and Sweppy. And what we're talking about is the offer for leasing for a 10-year gas lease. 10-year gas lease. 10 years. Only company that I see in Pennsylvania offering 10-year leases is Sweppy or Shell. We'll use those terms interchangeably. That's the only company that I see, that Doug Clark sees in Pennsylvania, offering 10-year leases. All the other companies that I deal with that I can remember and think of are all offering 5-year leases. And I'm just being extra careful. But the reality is I can't think of any other company that I've dealt with, and certainly any company that I deal with regularly, offering a 10-year lease. It just doesn't happen. Doesn't happen. I hope people are listening to this in Tioga County. You're the only place where this is occurring. And why? Because probably in other areas, nobody would sign a 10-year gas lease because they know that that's too long. They don't want to give a company 10 years. And I'll tell you, a thing that drives me crazy is you got a company offering people a 10-year gas lease, and it's the same company that has a bunch of vertical wells drilled straight down to the Marcellus that aren't producing, that aren't connected to pipelines. There's a bunch of these out there, and people are just getting these annual yearly shut-in payments at $5 typically an acre. And they've been getting them for years and years upon years. So you sign a 10-year lease. Well, the company doesn't even have to actually drill in 10 years. They get a permit. But let's say they start drilling in year 10. Let's They finished a well. Everything's done. Let's just say it takes them to year 11. Well, now in most of these offers, they have at least 5-year shut-in provisions, which allow the company to say finished a well in year 10 or 11, either one, then pay you an annual shut-in payment each year while gas is not being produced or transported to market. In other words, you're not getting royalties. So you got a well drilled there, and it could be sitting there for another 5 years. So your 10-year lease can absolutely turn into 15 years until you ever see a royalty. Does it mean it will? No, it doesn't. Does it mean it could? Yes, it does. So the company says, oh, well, we're going to drill next year. Hurry up and sign. Multiple things there. Why hurry up and sign a lease that is going to be a 10-year lease? Why hurry? Why hurry to sign a lease that is going to be active for 10 years? What's the big hurry? It's not a 2-year lease. It's not a 1-year lease. It's not even a 3-year lease. In fact, it's not even a 5-year lease. It is a 10-year lease. So the landman says, hey, hurry up. We got to get this signed. We got to get rolling. Well, where are you rolling to? Where are you rolling to? Why do you need 10 years, company? Why do you need 10 years? Why do you need 10 years? On top of that, why do I sign a 10-year lease now when you as a company tell me, or I read and I watch the stocks and I watch the investors' information in the conferences and I look at this stuff and we say, why do I sign a 10-year lease today? First off, ask that a couple times over. Why do it today? Then ask, why do it today when the company recognizes that, and everybody recognizes, gas prices are down, the budgets are low, they don't have money or money that they would typically have in the event the gas prices were higher. So why would I make a commitment today to a 10-year lease at whatever rate you're offering, such as $1,000 an acre? Why would I do that today when you as a company recognize that times are tough? You don't have money. Don't have the money you have in other scenarios whenever gas prices are higher. So why do a 10-year lease when the market's down? Why? Well, I'll tell you here. Here's the reason why people should, and I understand why people would do this in this scenario. If you're offered $1,000 per acre, $1,000 per acre, and you say 10-year lease, I don't like any of that because I'm a reasonably intelligent person. I know that's I don't like that at all because I'm a reasonably intelligent person. I recognize I don't like it. So I have 100 acres. If I sign this and everything goes through and I get paid, if I sign this, I get $100,000 in the next 100 days or so. So maybe that $100 helps pay for your son or daughter's education. Maybe it helps you retire earlier. Maybe it takes care of some bills that have been on your back or something that is very important to you, that money is going to change your life in some fashion or help you significantly. Well, that's a bird in the hand once you get paid. That's a bird in the hand. And then you say, well, if I get anything at all in the future, hey, that's good. Okay, I understand that. I hate to see people make these decisions because of that type of scenario, but I absolutely understand that. But if this is not life-changing money to you, then I think you need to ask a series of further questions, leading with, why do I want to do this today? Well, you may turn and say, well, I want to do this today because I like the royalty percentage. Well, insert that buzzer sound here, because the royalty percentage is the lowest possible allowed by state law. Lowest you can get. Can't do worse. Cannot possibly do worse than 12.5%. You may say, well, because I'm not going to have post-production cost deducted from my subsequent royalty payments. And I'm a smart landowner. I'm informed. I know that post-production costs can be extremely expensive and eat the heck out of my royalty payments, even to the point where they eat all of your royalty payments. I'm going to talk about that here in a second. You're listening to All Things Marcellus with me, attorney Doug Clark of the Clark Law Firm. So, okay, what am I saying? What the heck is this guy talking about eating up your royalty payments? So I'm going to explain. There are many people today, as of the date of this show, who are leased to Chesapeake. Chesapeake is pumping their gas, taking it to market from wells that they're participating in. They're part of the wells. They get royalties from these wells. These landowners do. Chesapeake is extracting the gas, taking the gas out of the ground, taking it to market, selling it at market. Now here comes the end of the month. Landowner says, okay, hey, let me look for my monthly royalty check. They go out to the mailbox. It's not there. They go the next day. It's not there. They go the next day. It's not there. I think you're getting my drift. There's no royalty check that comes. Well, how is that possible? How in the world is that possible? Gas company pumping gas, selling gas, no royalty check comes. You say, what's going on? You contact Chesapeake. Chesapeake says, well, landowner, your gas, yes, it's correct. We've been pumping, transporting, and selling gas from your wells. That's true. But our post-production costs, the cost that we are incurring to transport the gas from your well site to the point of sale where we're selling the gas, those costs are higher than the price that we're getting for the gas that we're selling. What do I mean? Here we go. So if the gas is sold at $1 per MCF, we'll say per unit of gas. If it's sold for $1, Chesapeake in these cases, this is an illustration, is saying, yes, we're getting $1 for the gas that we sold. However, the post-production costs that we're incurring to get the gas to that sell point where we sell it at $1 is costing us $1.01. So therefore, you, landowner, this month are not going to get any royalty because the price of your post-production costs actually exceeds the price that we're getting for the gas. So the landowner's gas is being extracted from the ground and sold, and the landowner is not getting a dime of royalty because the post-production costs are eating up the entire, not 50%, not 70, 80, 90, 100% of the royalty payments. You're not getting royalty, but your gas is being sold. Why? Because post-production costs are being deducted. Because deductions are killing your royalty, and you get not hardly any. You get no royalty whatsoever. That, ladies and gentlemen, that can be the impact of post-production cost deductions. That can be the impact. It's happening right now as I do this show. You're listening to All Things Marcellus with me, attorney Doug Clark of the Clark Law Firm. So here's what I'm saying. So listen, back again. So you're out there, Tioga County, Shell comes out. Oh yeah, we want to give you a lease offer. We want to give it to you for 10 years. You say, what in the world? 10 years? Say, hey, I listen to that Doug Clark radio show, All Things Marcellus, every week. And I say, you're the only guys offering 10 years. You're the only company out there regularly offering 10-year leases. why sign a 10-year lease with you? Why? Why not sign a lease when you're getting ready to drill? Why sign a lease that gives you 10 years to drill? Well, the only good answer, in my opinion, to that is, well, landowner, we're going to give you $1,000 per acre, and you can get that money in the next 90, 100 days, whatever that payment term is. That's the only reason, in my opinion. Now, again, not specific advice for anybody. We got to look at your specific situation. But why do a 10-year lease? Again, why do it when the market is what the market is? When the company says, we don't have any money. You're lucky we're even giving you anything. Well, geez, maybe I should wait. Because this isn't a 1 or 2 year lease. You're not telling me you're drilling tomorrow. You're not going to drill in 2017. What you're telling me is you have no commitment to me when you're going to drill, when you're going to develop, other than you have 10 years to not even drill, but to apply for a permit. But we'll say 10 years to drill, even though that's not the case. We're going to be nice. And then after you drill, you can shut that in for another 5 years minimum, and I never get a dime. So why do this today when the market is what the market is and you don't have money that you have whenever gas prices are higher? Why not wait? Well, again, one very understandable reason is $1,000 per acre, and maybe that money's going to change your life. But, hey, say that money changes your life today. What if in a couple years, and this is an if, no promises here, but what if, the offer goes to $2,000 an acre in the future? Well, you just doubled that money pretty darn quickly. If that occurs. Now, let's not go so far iffies. Let's go for concrete things, such as royalty percentage. So again, do I sign it because I'm getting a good royalty percentage? No, because you're getting the lowest possible royalty that Pennsylvania law allows. Lowest possible royalty. And I don't care if you bump it from 12.5 to 13.5. Not that big of a deal, guys. Oh, okay. So you may have flexibility to go to 13, but let's talk about 12.5 because that's what you're offering. And then you say, I want 15. I want a higher percent. Oh, well, maybe we can do 13.5. You're the one company telling us how great these wells are, but yet you can only pay us 12.5% royalty and take full deductions. All right, I'm not done on this. I am Attorney Doug Clark. You're listening to All Things Marcellus. And make sure to join me every Sunday from 8 to 9 a.m. on this station, and I'm going to be right back after this break. Welcome back to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. I want to jump right back into this because I'm getting once again fired up because I'm telling you, got to be asking yourself these questions. Tioga County landowners especially, you get these offers, 10-year lease, 12.5% royalty. Once again, the lowest possible royalty that any company can give you. The biggest crook on the planet can't give you less than 12.5% royalty. Then on top of that, the company says, oh, yeah, we're going to take full and total deductions. Well, I don't want deductions. Why? Because I'm an informed landowner. I understand what the impact of deductions can be. And I understand that those deductions at the present time are actually eating up in landowners' entire royalty payments. I gave that example before. Chesapeake, right now, as I do this show, there are landowners. Their gas is being pumped. It's being extracted from the ground and sold from their properties, and the landowners are not getting royalty payments from Chesapeake. And the question is, hey, Chesapeake, where's my royalty? I see the gas being pumped. I know it's being pumped. Where's my royalty statement? Chesapeake says, well, landowner, bad news. We're selling it for $1, but it's costing us $1.01 in post-production cost. So when we deduct that $1.01 from $1, you actually, in theory, you would owe us a penny, but they don't do that. So don't, you hear that rumor. I've never seen that, but it's no joke. It's not funny. Landowners are having their gas sold and not getting any royalty because post-production costs are eating every cent of their royalty. Now, that's not what you see all over the place, but it's occurring. And in other areas, I talk to landowners all the time. I used to be getting $10,000 a month. Now I'm getting like $300. Things like that. That's an illustration. I hear that all the time. I used to be getting thousands and thousands. Now I'm just getting a few $100s. That's what's occurring. Okay. So again, why now do you want to enter into a lease in this market? You have to ask yourself that question. Well, why? Because it's a good lease. That's why, because it's a good lease and I'm comfortable with it. Well, you better start investigating the lease. Again, they put that carrot. They put a carrot in front of you. That's the motivator. Here's the $1,000 per acre carrot that we're going to put in front of you. By the way, landowner, remember, you're going to pay taxes on that. But that's the carrot in front of you. Then, all of a sudden, you can't just be mesmerized by the carrot. You got to look what's, hanging around that carrot. What's hanging around that carrot is a 10-year lease. Longest lease that I see being offered out there in Pennsylvania. In fact, I've never seen a lease longer than 10 years. Okay, 10-year lease, we beat that up. Royalty, 12.5%. I can't say it enough, so please forgive me. But again, it's the lowest allowed in the state. They can't give you any less. So if you don't enter into an agreement and you enter into an agreement in the future, I will guarantee you this. I will guarantee you can't do worse than 12.5%. And full deductions. The company says we're going to take full deductions. Then they also say, well, Shell, that's a non-starter. They have to take full deductions. No, they won't budge on that. They won't budge on that. And look, time will tell. Maybe that's true. Maybe it's not true. But I can tell you something that is true because I witnessed it. And I witnessed previously Shell say, we're never going to give any royalties without deductions. We're not going to do it. And then all of a sudden, the position changes and they agree to a royalty provision, which they state says no deductions. I'm not saying that's going to happen again. I can't say that, but I can tell you this. Just because somebody says or a company says we're not going to do something doesn't mean that they're not going to ever change their position. Think about the leases. I mean, boy, I say this. I remember so well, so many times, landmen say to me, yeah, company's not going to pay anymore. This is tapped out. This is as high as it's ever going to go. And then a day or two later, maybe even longer, a month or so, but literally sometimes the next day when things are really heated up, the offers would change significantly to the betterment improved for the landowner. That happened routinely. So to say we're not going to do something, I hear that all the time. I hear, well, yeah, we're offering you $50,000, your client wants $100,000, you're nuts, you're crazy, we're not going to do it. And then many times they come back and they do exactly what they said they weren't going to do. It's not uncommon. Believe me, it's not uncommon. And I'm not saying that Shell will ultimately agree to pay royalties without deductions. I'm not saying they will. I don't know. Time will tell. But I can tell you this, they may, and it depends on how landowners react. Also, my personal opinion, I suspect, I have no idea, it may never, ever happen. But it may, and I suspect that there's a good chance that Tioga County landowners in the future will be offered 15% or more. It's all driven by the market. That's not a guarantee. It's not specific advice. But I'll tell you this, think about it. If everybody stopped signing 10-year gas leases, 10-year, just kills me to say it, gas leases at 12.5% and full deductions. If there's gas there, one of two things is going to happen. Company's going to say, well, hey, these guys, they're too tough. Let's pull out. We're not going to produce any gas. And then let's play it out. No other company wants to come in and pay 15% royalty. That's good. That's just too high, even though that's what minimum that pretty much every other company in the state that I deal with pays at a minimum 15%. Well, they're going to pull out and never come back and offer you anything else. Or if people stop signing people. If they do, then are they going to say, well, people don't like 10-year leases because they know that we're the only company out there regularly offering 10-year leases. Then they say, you know what? These people don't like 12.5% royalty because they're informed and they know that we're pretty much the only company out there offering 12.5% royalty. And we're darn sure the only company out there regularly offering 12.5% royalty with 10-year leases. Then on top of that, they say, these landowners, they don't like the fact that we have full ability to take full and total post-production costs and deduct them from their royalties. And they know that those costs in some cases literally can eat the landowner's entire royalty, that can occur. Doesn't occur all the time, doesn't regularly occur, but can occur. So landowners are saying, geez, I don't want to sign these agreements, so what's the company going to do? Pull out or offer more reasonable, more fairer agreements? Well, we'll see. Time will tell. Again, as always, not specific advice for anybody. These are my specific advice is to get you thinking, every person needs to do what is right for them and their family. I only want you as a landowner, as a listener, to be informed, to be educated, and before you sign, to understand all sides of that document as far as what it can mean today and into the future, and be informed and educated on what you're signing. And I promise, I know that you'll make the right decision. And that right decision may well be, hey, sign that document. That absolutely may be the right decision for you. But my concern is people are signing without having that understanding, that education, that evaluation. And how is that occurring? Because, in my opinion, they're relying on what their adversary, and I don't mean adversary in a traditional sense, I mean you have a company who wants to have you sign a contract. These are contract negotiations. The company wants what? The best contract for them. You as a landowner, you want the best contract for you. The company hires intelligent, educated, trained people to write and negotiate and communicate with you, the landowner. They hire those people. Why? To get the best contracts. So you as a landowner need to make sure that you're educating yourself and protecting yourself. And where do you do that? Do you do that from the company landman? Here it is. Of course not. Of course not. Why not? Why would you not be educated by the company landman? Why would you not rely on the company landman to do what's right for you, your family, and your circumstances? Because they work for the company, not you, the land owner. The landman is not employed by you. Ask them if they have a business card. See what names are on that business card. Look closely. See if you can find your name. I don't think you will. So whether it is me or somebody, get somebody who's representing your interest. Get an understanding. Get someone, too, who knows what they are doing. I hear land guys out there, oh, you should hire this guy. You should hire that guy. Well, why do they want you to hire this guy or that guy? Well, probably because they know that attorney is not going to put much effort in, or maybe even doesn't know what they're doing, or just has all their people sign. It's about education. I have had represented clients. Look, I'm not anti companies. I'm what I am is anti people being taken advantage of. We do deals. We do agreements all the time. Hundreds and hundreds and hundreds of leases. Like I say, pipeline agreements with 60 plus companies in Pennsylvania. Like, we do deals. We do them all the time. But we do the fairest, best deals that we can get. And if it's a bad deal, we don't need to do it, and it's going to be taking advantage of you, then landowners, if they want to, they can do it. But they're informed and generally say, hey, look, thank you, but no thank you. Bad deal, and I don't want to do it. You're listening to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. You can join me right here every Sunday from 8 to 9 a.m. on this station. And if you miss any of today's show, go back, check out pagasleaseattorney.com, pipelineattorney.com. Today's show will be up tomorrow morning, Monday morning, And we have hours and hours and hours and hours and hours and hours and hours of shows available on the websites. Again, pagasleaseattorney.com, pipelineattorney.com. I'll be right back after this break. Welcome back to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. You can always contact me, 570-307-0702, 570-307-0702, and join me right here on this station every Sunday from 8 to 9 a.m. because we're bringing you the information that you need regarding natural gas development here in Pennsylvania. So, okay, I want to now switch gears some because I also want to blast, in fairness, I don't want to just blast bad lease offers. I also want to blast bad pipeline offers. And let me tell you, there's plenty out there to blast, and in particular in Tioga County. And let's go ahead and give you an example. So, say you're offered a pipeline agreement for $5, maybe $7, well, maybe big time. Maybe you're offered $10 per foot of pipeline. I would say first thing that you should do, again, is take a big step back and follow that with another big step back, and then a few more big steps back, big steps back, a few more. Bottom line, get away from it, in my opinion. It's not enough money. It's not enough money. Plain and simple, not enough money for a permanent easement, a burden on your property. And you hear the landowners say this all the time. You have to pay taxes on that property. You can use the property, agricultural purposes, but you can only use the property in a way that will not and does not obstruct or impact the pipeline on the property. Can't build on it, can't put structures on it, can't have water accumulating in the area of the easement. It's a burden. It absolutely does not, I don't care what anyone says, does not increase the value of the property. Think about it. You were going to buy a property, one lot has a pipeline on it, natural gas pipeline, the other one doesn't. Which one do you want? Well, unless you like pipelines on your property for some reason, I think you're going to take the one that doesn't have the pipeline right-of-way on it. So you're going to burden your property. You're going to devalue the property. You better not be exposing yourself to lawsuits that may occur during the construction phase, the clearing phase, or even after the pipeline is in place. You got motorcycle, dirt bikers, ATVs, snowmobiles. You have now an increased potential to be sued. I don't care what anyone says. That's the truth. You need to make sure if you're entering into a pipeline right-of-way agreement that you understand everything and you're doing it for the right reasons and that you're going to be compensated fairly and appropriately and you're going to be protected from liability. It kills me when I see pipeline companies offer people contracts, get them to sign contracts, and there's no indemnification language in there. There's no language that says, yeah, if you get sued, we'll defend you. If there's a judgment against you, we'll pay it. That's not even in a lot of these offers. And why would you sign something that you're going to be exposed to liability? And generally speaking, all you have to do is ask for a protection and you can get it. But why isn't that automatic? Why do you even have to ask? And it's not every company, but there's a bunch of companies out there who offer standard right-of-way agreements without any liability protection for you, the landowner. And when you see that, that tells me a lot about that particular company. That tells me a lot about that company that they would offer you that type of an agreement. You're listening to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm, and I'm talking about bad pipeline agreements. So we're going big picture. We're talking about $5, $7, $10 per foot for payment. Then on top of that, that's, it's one of these other things like the leases. As if 10-year lease wasn't bad enough, then they got to give you the lowest possible royalty and say we're going to take full deductions. Here, if $5, $7, and $10 a foot isn't bad enough, and it's really bad in my opinion, really bad, really, really bad, please hear me, really bad. if you don't find that really bad, then start reading the actual document. Read the document. Also, don't fall victim because there's some map or there's something attached to the document that's guaranteed where the right-of-way and easement and pipelines are going to go. Don't fall for that, because you need to go deeper, because I see many agreements out there. It's not specific to anyone. I see a lot of agreements out there that, they throw a map and make you think something, but that map, if you read the documents, doesn't say that's actually where they're even going to put it, or that, they may intend to put it there, but reserve the right to change it and possibly put it anywhere. These agreements are not fair for you, the landowner. These agreements must be negotiated. Whether you retain me to help you or another lawyer, get a lawyer who knows what they're doing. Don't get a lawyer that's just going to roll over and say, oh, yeah, this looks good, this looks good. If any lawyer looks at one of these contracts and says, oh, yeah, this looks good, I'd start taking some steps back from that lawyer's office too, because I've never seen one of these pipeline agreements that I'd say, oh yeah, that's a great agreement. Not even close. I mean, never close. Sometimes we add 5, 6, 7 pages to these agreements. They're really, look, you got to look at your situation. But there's some really, really bad agreements out there. So let me give you this example. You're listening to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. Here's an example that just came up. Landowner, Tioga County, gets offered, oh God, I hate saying it, $10 a foot. $10 a foot. I don't know that I've ever had a client sign a right-of-way agreement. Remember, dealt with agreements, 60-plus different companies, 100 plus, I don't know, a couple hundred, few hundred, I don't know, maybe more clients signing pipeline right-of-way agreements all across the state of Pennsylvania, Commonwealth of Pennsylvania, everywhere, all over the place. And I can't think of a single case where I had a client paid $10 per foot. Early on, 2009, 10, 11, maybe we had some early for 15, but I can't recall a $10 per foot. Now, there may be a one or two out there or something, but I can't recall it. I certainly can't recall it any time in the last 4 or 5 years. I don't recall it at all, and I don't think it's occurred. So, $10 a foot. Well, if you got 1,000 feet, you're talking about $10,000. I had a client, I'll be conservative, client less than $1,000 or 1,000 feet get $250,000 before. $250,000. $250,000 for 1,000 feet, and actually less than 1,000 feet of pipeline. Here, 1,000 feet is offered at $10,000. $250,000 on one side, $10,000 on another. Which one would you rather sign? So I want to say not everything's the same. Different circumstances are different. There's a lot of different things that go into these. But as a general principle, $10 a foot just doesn't seem fair to me. Doesn't seem fair. And the reason why companies are offering it is because you're going to have landowners who will unfortunately sign whatever it is that you put in front of them. They'll sign it. So you have to make sure that you're not one of those people. Stop signing. Stop simply signing what is placed in front of you. I deal with landowners who signed what was placed in front of them several years ago, and now we deal with the problems. The time to address the problems is before you sign the document, not afterwards. So stop signing, get information, become educated, become informed. So here's the example. Landowner gets a small pipeline right away on their property. And look, let's call it 500 feet. Nice, easy round number. 500 feet. Well, if you're given $10 a foot at 500 feet, that's a whopping $5,000. Now, look, $5,000, nothing to sneeze at, but we're talking about $5,000. So then you get an agreement, and now you're going to get, if they use the pipeline, you're going to get $5,000. If they construct the pipeline. Oh, so you're going to give them 5 years to decide whether to do it, but we're not going to get too far there. So you're going to get $5,000. Well, you get the document, and it's a terrible document. It doesn't have any protections in there. It doesn't have any limitations, despite what the landman is telling you that they plan on doing, which maybe they do. A lot more can happen. A whole lot more can happen. Things can change. Route can change. All kinds of things can happen. And you're getting a grand total of $5,000. So you need to protect yourself. So you should, specific advice for everybody, whether me or somebody, you should have legal counsel to, if nothing else, review and consult with you about the document before you sign it to make sure that's what you want to do. But any lawyer who's worth anything, in my opinion, who does this, I mean, you have to do this stuff. If you don't do it, you don't know. It's the same with anything. There's many areas of law. I know nothing about divorce other than what I learned in law school 20 plus years ago. But anyway, what you need to do is you need to understand this document. And if you do, you're going to understand, hey, I do not want to sign this document the way it's written. So now what do you have to do? You have to negotiate. You have to change the language. Well, as an individual, I don't care how much internet research you do. The truth is, it's impossible, in my opinion, for any single landowner to do this themselves and to do it as effectively as it should be done. I really believe that. I just believe that. And I believe it to be true because I learn stuff every day. I do this all the time and I learn things every day. So now, in order to get an agreement that's worth signing for your grand total of maybe you get $5,000, well, now you need to negotiate. You need to work on it. So you hire a lawyer. Let's say, and because the document's so bad, maybe it's going to take you, I'm going to use again a round number. Let's say it takes $1,500 in legal fees to get this document to the point where you're satisfied to sign it. So now you got your $5,000 payment after taxes. Let's say you bring home, we'll be nice, we'll say $4,000. Now you paid attorney fees, so minus $1,500 from there. Now you're at $2,500 is what your take home is. And what do you have now? You have a permanent easement on your property that's devalued and encumbered your property. You got an area of property that you can't build on, that you can't impound water on. You have all these restrictions, and God forbid, you pray you don't get sued at any point in time as a result of this pipeline on your property. So, do you want to do that? You need to ask your questions. I don't think so. Not for $5,000. Doesn't make sense. And you know what? People aren't doing it. Not the informed, not the educated people. They're not doing it. They know better. And we want you to be informed, and we want you to know better and make the right decision. That's what we want, for you to make the right decision and ask the right questions. You're listening to All Things Marcellus with me, attorney Doug Clark of the Clark Law Firm. We're here to help you. If you need representation, you want to learn more about consultations and reviews, you can always contact the office, 570-307-0702, 570-307-0702. Regardless of your location, give us a call, learn about these reviews and consultations. Please be careful. We just want you to I just want you to make the right decision and not be taken advantage of. And you have the power to do that. And the power is acquire quality information. Whether it's me or somebody else, get good quality information and good high quality representation. It's too big of an asset. It's too big of an opportunity to just throw away and not to do right. You don't generally get, and very rarely do you get a second bite of the apple. You got to do it right. You got to do it right the first time. All right, that's all we have time for today. But remember, you can join me right here on this station every Sunday from 8 to 9 a.m. And let me leave you, as always, with a couple things. 1, stop signing bad agreements. 2, remember, the landman works for the company, not you, the land owner. So join me next week and have a great week, everyone.